M&A diligence is the workflow that decides whether a deal closes on time, whether the buyer gets the price they agreed to, and whether the partner running the transaction sleeps for the 4 weeks between signing and closing. Hundreds of contracts, dozens of corporate records, layers of subsidiaries, multiple jurisdictions, and a counterparty who is being cooperative but only to a point. The associate team works 15-hour days. The partner reviews their work at midnight. The senior counsel on the other side emails at 6 in the morning with new questions, and the clock to closing keeps moving, regardless of how many people are working on it. The corporate legal plugin in the Claude for Legal release addresses the workflow that consumes more transactional practice time than any other piece of M&A work. The diligence sprint, the entity compliance grid, the corporate governance review, and the deal close checklist. The architectural decisions inside the plugin suggest Anthropic spent serious time with practicing M&A partners before shipping, because the plugin behaves the way an experienced practitioner would build it if they were building it for themselves. The panel's view from the launch materials is that corporate legal is the plugin that opens up the highest billing rate work in legal practice to AI assistants for the first time in a way that matters. This episode walks through the 4 named workflows, the configuration question that shapes how the plugin behaves on every deal, the workflow that changes most under the plugin, and the strategic implication for the M&A practice over the next 12 months. One integrity note before the walkthrough begins. The panel has not yet deployed corporate legal on a live transaction. The analysis here is built from the launch documentation, the GitHub repository, and the panel's collective M&A experience. The deployment report comes in a later episode, once 30 days of real deal use have built up the evidence base. Corporate legal opens with a cold start configuration that takes around 15 minutes to run through. Longer than commercial legal's interview, because M&A work is more heterogeneous and the plugin needs to understand more about your practice before it can be useful. The configuration has 4 sections, and each one shapes how the plugin behaves on every subsequent transaction. The first section asks about your deal profile. Are you predominantly buyer side or seller side? What size of transactions do you typically run? What industries do you work in most? What jurisdictions are most relevant to your deal flow? The plugin uses this to calibrate its default posture on the diligence questions that matter most for your practice. The second section asks about your firm's standard diligence playbook. What categories of risk do you always investigate? What thresholds trigger escalation? What documents do you always request from the seller? The plugin uses this to populate the diligence grid template that every transaction will start from. The third section asks about your firm's standard deliverables: diligence reports, red line tracking, issues lists, board memos. The plugin uses this to format its outputs so they match what your team actually produces, rather than producing something generic that requires reformatting before it can be used. The fourth section asks about your active deal flow: the deals you are currently running, the matter codes, the counterparties, the closing dates. The plugin uses this to build the matter file that subsequent work will reference. This is the section that compounds. The plugin gets materially better at your practice as more deals flow through it. After those 4 sections, the plugin asks for 5 recent closed deals, with the full document set if you can manage it. The plugin needs to see how your team actually runs M&A work, not just how you say you run it. The gap between stated playbook and actual practice is real in every transactional team. And the plugin learns from the closed deals rather than from the stated positions alone. The panel walks through each of the 4 named workflows with the same 4 questions, because the questions are the same ones a senior M&A practitioner would ask before adding any new tool to their deal stack. What does the workflow actually do? What work does it enable that was not possible before? Where is the gain most visible, and where, inevitably, do the gaps show up? The 4 workflows are diligence sprint, entity compliance, corporate governance review, and deal close checklist. Each one targets a different stage of the M&A timeline, and the 4 together cover the transactional workflow from the initial diligence kickoff to the post-closing integration period. Diligence sprint runs from the moment the data room opens to the moment the diligence report is delivered. Entity compliance runs across the seller's corporate structure to identify entity-level issues that affect the deal. Corporate governance review covers the board resolutions, officer appointments, and governance documents that the buyer inherits at closing. Deal close checklist is the systematic walkthrough of every condition precedent, every closing deliverable, and every post-closing obligation that has to be tracked in the weeks after signing. The 4 workflows compose. The output of diligence sprint feeds the issues list that drives the corporate governance review priorities. The entity compliance grid feeds the deal close checklist on the entity-level conditions precedent. The plugin holds the matter file across all 4 workflows, so the partner is never reconstructing context when moving between them. Diligence sprint is the workflow that defines M&A practice for the buyer-side associate. The data room opens. The diligence period clock starts. The partner has set expectations with the client about what the diligence will cover and how long it will take. The associate team has to review hundreds of contracts, identify the issues, document them in the diligence report, and surface anything that materially affects the buyer's valuation or the structure of the deal. The plugin reads the data room, applies the firm's standard diligence playbook, and produces a populated diligence grid with every contract reviewed against the standard risk categories. The output is structured the way the partner expects to see it. Risk categories down one axis, contract types across the other. Each cell either confirms compliance or flags a deviation with the supporting contract language quoted in line. The partner reviews the grid the way they would review an associate's first pass, with the same kind of attention, but on something already organized rather than on raw documents. The gain is substantial. A diligence sprint that used to take a 4-associate team 3 weeks now takes the same team 8 to 10 days, with the senior associate spending more time on the issues that actually matter and less time on the production work of reading every commercial contract to confirm there is no change of control trigger. The plugin does the production work. The associate applies the judgment. The gaps show up around 2 specific patterns. Unusual deal structures where the standard playbook does not match the actual risk landscape. The plugin will produce a grid that misses the structural issue because the issue does not fit the standard categories. The senior associate has to add the missing category and rerun the relevant subset of contracts. The second gap is heavily redacted data rooms, where the plugin cannot fully analyze contracts that are substantially blacked out for confidentiality. The plugin flags the redactions, but cannot solve the underlying problem of incomplete information. Entity compliance is the workflow that consumes the most junior associate time and produces the issues most likely to delay closing if missed. The seller is a company with 70 entities across 12 jurisdictions. Each entity has its own corporate records, its own officer appointments, its own annual filings, and its own jurisdictional compliance obligations. The buyer's counsel has to confirm that every entity is in good standing, every filing is current, and there are no pending matters that affect the acquisition. Traditionally, this is a paralegal-led workflow that takes weeks and produces a multi-page entity matrix that the senior associate then reviews. The plugin reads the corporate records, pulls public filings from the relevant Secretary of State or company registry equivalents, and produces an entity-by-entity compliance grid. Good standing confirmed or not, annual filings current or overdue, officers appointed properly or not, material litigation flagged or absent. The output is the same matrix the firm has always produced, populated faster and with verification links back to the source filings. The gain is twofold. The production work compresses dramatically. A 70-entity compliance review that took a paralegal 2 weeks now takes 3 or 4 days. And the verification is more rigorous because every cell in the matrix carries a link back to the underlying filing that supports the conclusion. The senior associate can spot-check the cells they are most concerned about rather than redoing the paralegal's work to be sure. The gaps come from non-U.S. entities and from offshore jurisdictions where the public filing infrastructure is thinner. The plugin handles Delaware, the major U.S. states, and the U.K. confidently. It handles EU jurisdictions with varying quality depending on the country. It handles Cayman, BVI, and other common offshore structures less reliably. And the practitioner needs to verify offshore results more carefully than U.S. onshore results. Corporate governance review is the workflow that the senior associate spends most time on because it requires the most judgment. Board resolutions, officer appointments, charter documents, bylaw amendments, written consents, and the chain of governance actions that establish whether the company can actually deliver what the buyer is paying for. The legal title to the assets the buyer is acquiring depends on the corporate governance being clean. If the governance is not clean, the deal either gets restructured, gets repriced, or does not close. The plugin reads the governance documents, traces the chain of authority for each material corporate action, and produces an exception report identifying any governance defects that need attention. Board action without a proper quorum. Officer appointments without supporting resolutions. Asset transfers between subsidiaries without supporting board approvals. Shareholder approvals required by charter but not obtained. The exception report is what the senior associate works through with the seller's counsel to get the governance cleaned up before closing. The gain is the structural change in how governance review works. Traditionally, the senior associate reads every material governance document to identify the exceptions, which is hours of careful reading. The plugin produces the exception list directly, and the senior associate spends their time on the exceptions rather than on the reading. The work that requires senior judgment expands. The work that does not require senior judgment compresses. The gaps show up around novel governance structures and around bespoke corporate documents. Standard Delaware corporation governance is handled well. LLC operating agreements with non-standard provisions, partnerships with complex distribution waterfalls, and trust structures require more verification from the senior associate because the plugin's training is thinner on these structures than on Delaware corporation work. Deal close checklist is the workflow that determines whether closing actually happens on the day everyone has been working toward. Hundreds of conditions precedent, dozens of closing deliverables, multiple wire transfers, signatures from board members across multiple time zones, and a counterparty whose counsel is doing the same workflow in parallel. The senior associate's job in the week before closing is to know exactly where every closing item stands, what is outstanding, who is responsible for resolving it, and what the path to closing looks like by the hour. The plugin reads the purchase agreement, the disclosure schedules, the closing checklist from prior similar transactions, and the running status of the diligence work. The output is a structured closing checklist with every condition precedent listed, the current status, the responsible party, and the path to satisfaction. The checklist updates as work progresses. The senior associate reviews the checklist 3 or 4 times daily in the closing week, and the partner reviews it at scheduled intervals to confirm the deal is tracking to close. The gain is calmer closings. The closing week panic that defines M&A practice is largely a function of running the checklist manually across multiple documents, multiple emails, and multiple status updates from different members of the deal team. The plugin centralizes the checklist and keeps it current. The senior associate's job becomes tracking exceptions and pushing on whoever is holding up each item, rather than reconstructing the checklist from scratch every morning. The gaps come from deals with unusual closing mechanics, earnouts with performance milestones, escrow arrangements with multiple release conditions, regulatory approvals from multiple authorities, and conditions that depend on counterparty actions outside the lawyer's control. The plugin tracks what it can see in the documents, the pieces that depend on judgment about whether a condition will be satisfied in time, still depend on the senior associate. I know what you are thinking. You are thinking that diligence is what you are paid for, that the value of an M&A partner is precisely the ability to read hundreds of contracts and spot the issues that matter, and that automating that work either takes the value out of the practice or, worse, produces a diligence report that misses the issue that actually kills the deal. The panel takes that concern seriously because it is the right concern, and the answer is not what the launch marketing for corporate legal would have you believe. The answer is that the plugin does not replace the diligence judgment. It changes which diligence work absorbs the partner's attention. The traditional pattern is that the partner reads the partner attention contracts and trusts the associate team's read on the rest. The associate team's read on the rest is the failure surface where mid-size deals routinely lose value. The buyer's counsel finds the change of control trigger after closing because the third-year associate did not flag it during diligence, because the third-year associate was looking at 200 contracts in 3 days. The plugin reverses the failure surface. The partner attention contracts still get partner attention, but the remaining contracts now get a consistent first-pass review that does not depend on how tired the third-year associate is, how many other contracts they have already read today, or whether the issue is in a clause type they have seen before. The diligence quality on the long tail of contracts improves substantially. The partner's attention now goes to the issues the plugin has surfaced, rather than to the contracts the plugin has read. In practice, this means partners running corporate work with the plugin do not become less senior. They become more focused. The work that requires their judgment expands. The work that does not require their judgment compresses. That is the change to be honest about. The plugin does not take work away from the M&A partner. It takes the right work away. The corporate legal plugin handles M&A work with sophisticated playbook intelligence, but the durable verification skills the panel has covered in the Foundation series still apply in full, and the practitioners who skip them in favor of trusting the plugin output are setting themselves up for the most expensive kind of mistake the M&A market produces. Verify every citation from Foundation's number 6 applies to every legal authority the plugin cites in support of a diligence finding. Most of the plugin's outputs do not turn on case law authority, but the ones that do, the fairness opinion analysis, the appraisal rights memos, the indemnification analysis, all rely on jurisdictional case law, where verification matters as much as it does in litigation work. Run the citation check. The 5 Qs protocol from Foundation's number 7 applies to every research memo the plugin produces for a transactional issue. Corporate deals generate legal, research questions constantly, often under time pressure, and the prompt level discipline that catches fabrication before it reaches the diligence report is exactly the discipline that protects the partner's signature on the opinion that goes into the closing binder. Build a chronology in an afternoon, from Foundation's number 5, becomes the document trail for any pre-deal litigation the buyer is inheriting. M&A diligence routinely surfaces pending matters, threatened claims, and historical disputes that require the buyer's counsel to understand the sequence of events before recommending deal-level allocation of the risk. The chronology methodology is how that sequencing gets done quickly enough to inform the negotiation. Step back from the four workflows for a moment and consider what corporate legal does to the M&A practice over the medium term, because the implications go beyond productivity improvement and reach into how the function itself is organized. The economics of the M&A practice change. The fee model has historically depended on the number of associate hours required to complete diligence. The standard allocation has been roughly 70% of the deal fee going to associate-driven production work and 30% to partner-driven judgment work. The plugin compresses the production work by 60 to 70%. The 70-30 split inverts. The work that justifies the fee shifts to judgment and away from production, and the firms that adjust their pricing and staffing models accordingly are the firms that capture the value of the change. The career trajectory of the M&A associate changes shape too. The traditional path has been 3 years of intensive production work that builds pattern recognition, followed by gradual elevation into more judgment-driven work as the associate becomes senior. With the plugin doing the production work, the new associate misses the pattern recognition apprenticeship that the production work provided. Firms that recognize this are starting to invest in different training models, where junior associates work alongside the plugin to develop pattern recognition more deliberately than the apprenticeship model produced. For senior M&A practitioners with the seniority and the context to deploy the plugin well, this is the most material change to M&A practice in 20 years. The work compresses, the judgment expands, the fee model adjusts. The practitioners who recognize the shift early are the ones who will be best positioned when the rest of the market arrives at the same understanding 18 months from now. That was the walkthrough. The 4 named workflows in the corporate legal plugin, the configuration that shapes how each one behaves, the insight that distinguishes how the plugin changes M&A practice from how the launch marketing describes it, and the strategic implication for the function of corporate practice over the medium term. The deployment report comes in a later episode, once 30 days of real transaction use have built up the evidence base, and that episode will name the failure modes the panel finds in practice rather than the ones anticipated from the launch materials. The unpacked launch arc continues. Episode number 7 covers the employment legal plugin, which addresses the practice area where the plugin's playbook calibration matters most. The episode after that covers privacy legal, which is the practice area most affected by the cross-border regulatory complexity that the plugin's jurisdictional anchoring is designed to handle. The arc closes with product legal and AI governance legal as a paired episode, and the document layer connectors in episode number 10. If your practice touches corporate work in any meaningful way, the corporate legal plugin is the single most material change in the Claude for Legal release for transactional teams. Adopt it carefully. Build the deal profile thoughtfully. Maintain the configuration as the plugin runs. The lane is moving fast, and the firms that move with discipline now are the ones that will be best positioned when the dust settles. That's the episode. See you in the next one.